Hello, this is Brian Hortz, and I'm here to present Athletic Training Scope of Practice. How do we know what athletic trainers can do? And I'm appreciating the opportunity to speak with you today and your interest in this topic. And I've spent a lot of time thinking about scope of practice over the last decade and ways in which athletic training practice has grown, how scope of practice has changed. And I spent a 9-year stint on our Ohio athletic training, physical therapy, and occupational therapy boards. And so I spent a lot of time while I was on that board really thinking about scope of practice and how it impacted the ways in which the board looked at regulation. And so I'm going to kind of present to you some of the information, some basics about regulation in and of itself, and then talk about a document that I created both with the colleagues here in the state of Ohio, but one with the NATA that really talks about how we can kind of ferret out what scope of practice is and some ways of thinking about that question. So my objectives for today are to discuss the types of regulations that are across the country and how that impacts scope of practice. Scope of practice is really dictated by law, so understanding the type of regulation that you have in your state allows you to have a better understanding of the type of scope of practice you may or may not have as defined by that state. So we'll start with just giving a 10,000-foot view of regulation and the types of regulation. Then I want to get into kind of scope of practice issues. What are the current problems with scope of practice, the current kind of climate of scope of practice, and the issues that we're bumping into there relative to the medical profession in general and the interaction between professions. And then the nuts and bolts of this presentation are really an opportunity to provide a framework for understanding how we as a board thought about and how I kind of came to some clarity on trying to answer the questions of scope of practice when we met as a regulatory board and when we talk about what athletic trainers can and can't do within the context of that regulatory board. So when we work our way through this, I'm hoping that by the end we'll have a real nice, clear, concise idea of the regulatory process and the types of regulation, what the problems and issues are with scope of practice, and then a framework of understanding and thinking about how we define what that is. It really always starts with regulation in general. You know, why do we regulate? And I think there's a lot of misinformation, a lot of misconception about what regulatory boards are about. But often professions see regulatory boards as something to further the profession, to legitimize the profession, and in reality, the mission of any state board is to protect the health, safety, and welfare of the public. The only reason to put a licensure law or some type of regulation in is to actively look at a profession, regulate a profession so that it's safe for the public. And that's the same whether it's a barber shop or an athletic trainer or a surgeon, right? We're trying to protect the health and safety of the public of that state from those who are practicing within that profession, and also regulate what some minimum standards within that are. So we're going to talk a little bit about regulation and the forms of regulation, because they run the gamut from registration, which is the least restrictive, and we'll talk about registration, to certification and certification processes and what kind of the next level beyond registration is. And then we'll get into the most restrictive, which is licensure, and we'll talk, and I'm going to walk you through some examples of how licensure can be more restricting and how it restricts scope of practice. And I'll go through some examples from quite a few different states around the country. So a good place to start if you're looking for deeper information beyond what I'm going to cover here in the next, say 8 slides, is this Schmidt resource that is all about, answers to questions you may have about professional regulation and kind of getting to what these forms of regulation are and how they impact the states that have these varying levels of registration. It's quite a nice document if you want to go look at it, but we're going to just cover some basics on what is registration. Registration is a requirement that an individual register with the state Basically, you say, I'm here, I'm an athletic trainer, and here's my address, right? So there's no requirement that that person demonstrate any kind of standard competence or education. You just say, hey, here I am, and I'm claiming that I'm an athletic trainer. And the use of registration within a states are really to kind of get a sense for how many practitioners of a particular profession there are, and to give some idea of where practitioners are distributed across the state. And they use this when there's a low probability that an individual could inflict harm on the public, and that public safety is not really much of a concern. So they don't feel like they have to regulate with such a stringent method. The next most robust type of regulation is certification, and it regulates the use of occupational titles. So then not everyone can use that particular title unless they have some type of a certification. It prevents individuals who are not certified from using that designated title. And so therefore, it prevents people from claiming to be, say, an athletic trainer in a certification state unless they've passed the BOC exam. It also, one of the things that certification doesn't do is it doesn't prevent others from performing similar functions. It assumes that an individual meets minimum standards, and that those minimum standards are established by private certification bodies. Now, the interesting thing here, we get into a lot of discussions, and we'll talk a little bit more about kind of advanced skill training and certification in advanced skills. I think the key on this slide is private certification body. A lot of times we have, things like movement screen programs like FMS, or dry needling skill, or an instrument assisted class that is certifying, quote unquote, a practitioner in a method. That is not a private certification body, right? We're talking about a certification process similar to the BOC, where there's a body independent of the people who educate, that set a minimum standards, create an exam, have a process by which they can guarantee that the people that get their credential have some minimum standard within their practice. And so when we talk about certification, it's really that focus on this kind of private, separate certification bodies, and having some real floor on what skills people have. And then you get to licensure. Licensure is very much misunderstood. The profession thinks of licensing on more of a personal level, like what is the license doing for the profession, and how does it help the profession get some type of recognition, and really that's not what licensing boards are about. License is not about protecting jobs. It's not about validating a particular profession. It's about protecting the public's health, safety, and welfare. And so when we think about of why to license and why to go through licensure, we spend a lot of time within the context of athletic training talking about licensure as if it legitimizes our profession, when in reality, licensure from a state level and what the legislature is looking at, it has nothing to do with that. It's the legislative body permitting the government to say, we're going to regulate this profession. We think that there's a chance that this profession could do harm, so we have to create some kind of a minimum standard and some kind of an ongoing monitoring of the people who practice this profession, so we can make sure that the public's health, safety, and welfare are reasonably protected. And with licensure, the beautiful thing that comes out of it is that only licensed individuals may engage in the activities that are in the statute, and to some degree it does protect one's scope, although it really doesn't protect so much as just more clearly define what the boundaries of that scope of practice are. And I'm going to give you some examples of that towards the tail end of this presentation. But we spent a lot of time talking about licensure at a global level in the NATA and across our profession in ways that makes me think that it's for people, they see it as a legitimizing of the profession versus what it's actually all about. So licensure creates laws. They define what aspects of the practice are to be regulated. They establish minimum standards for educational requirements. And so, think if I'm really after public safety, I want to make sure the people who have this credential have some minimum standard. They meet some educational requirements. They meet some ongoing educational requirements so that they can stay safe, right? And the law also clarifies what unlicensed individuals may or may not perform within the context of that duties, or even some duties that can be delegated by licensees to non-licensed individuals. And so you'll see lots of these nuances in practice acts that really are attempting to establish these minimum standards and clarify what this practice of this profession is. And that occurs across the board, but the goal is always the same with licensure. It's to assure the safety of the public, and whether you're an athletic trainer or a barber or a dental hygienist or a surgeon, that the reason that practice act is there is for that express purpose. The other byproduct you'll see in a licensure law is this comes right out of the Ohio athletic training law. No person shall claim to the public to be an athletic trainer or imply by words, actions, or letters that a person is an athletic trainer unless the person is licensed. So it really says, if you gives some reasonable protection to the public that the person who's saying that they're an athletic trainer has met this minimum standards. Very different from that registration where anyone can say, hey, I'm over here, this is my address, and I'm an X, Y, or Z practitioner, right? Without any kind of an educational requirement at all. So it protects. This is, I think, where people get confused. It does, in some ways, protect the public by making sure that the people who are licensed are actually meeting educational requirements and meeting some minimum standard. So this came straight off of NATA webpage in October of 2019. So if this changes by the time you look at it, you can go out and take a look. But as you can see here, the preponderance of the United States falls under this more regulated, more stringent licensure requirement. But we do sample from all of the different types, right? We have no registration. We have registration in Hawaii. We have certification in New York and South Carolina. We have no regulation at all in California. So when we talk about these differing levels of regulation and public safety and what it means, it gives you a sense that different states see the practice of athletic training as or more or less safe, or that they need to protect the public from people practicing athletic training more or less, given the context. And so we're going to walk through and talk a little bit more about, why you have licensure. Again, from a state standpoint, it's to protect the public health. It's also a way of making sure that the people who are educated have minimum qualifications. It restricts practice in terms of what people can and can't do to make sure they're doing things that are safe. And it to some degree does legitimize the profession, gives it public recognition, and I think that's what most people focus on. But from a legislative standpoint, a senator or a legislator from a district in and around your state really doesn't have any skin in legitimizing any particular profession. When they're looking at a licensing law and where to put it in, I think what they're looking for is, does this make sense to keep the constituents of my district safe, and does it make sense that we would want to regulate this group so that we can assure that the people are safe? And so, it's kind of cross to what a lot of people think about when they think and discuss the purposes of regulatory boards. And so, you'll see things in the statutes of these regulatory boards that establish requirements for entry in the profession, right? And a great way to assure safety of the public, right? Make sure that everyone in the profession who's getting a license has some minimum requirement. They also adopt administrative rules. So not everything can be dictated in statute. They give rulemaking authority to the board so they can more clearly define practices and ways in which the board will go about achieving and meeting the legislation, the law itself. And there's big purpose, again, if you're after safety of the public, then one of the big purposes here is going to be disciplining licensees, right? So when someone's out of bounds, it's the board's job to make sure that that athletic trainer, that person, is being dealt with in an appropriate way. Assuring continued competence. So this is the continuing ed component, and this varies from state to state. So, we know what the CE requirement for the BOC is, and many of the states have just adopted that. But when you look at CE from the standpoint of public safety, not just education practice, there are some states who have decided, you know what, we really don't need as robust a number of continuing education units to assure that the practitioners in our state are being safe. And so therefore, many states have differing academic requirements, and even requirements outside of what the BOC has for licensees in terms of maybe ethics requirements, or beyond EBP, like a particular thing that state wants someone to review the law every cycle, right? So a jurisprudence exam. So you'll see different ways in which they conceptualize continued competence of their licensee and what Con Ed looks like within the context of that. And I think it's right and good that each state doesn't necessarily always have a boilerplate look at what that is. It makes sense that states might differ on what they think continued competence looks like. And so, you'll see in the statutes, in many of these regulations, this initial entrance examination requirement, which requires education, right? You've graduated from an accredited program, or you've had these types of courses. Like, they're going to specify what it is that it's required for you to even apply for a license. And then beyond that, they're going to assess initial competence. And they can do this using something like the BOC exam and saying, hey, that's all we need to be assured that you're going to be safe. But some states go beyond that. They have additional requirements. Some states have their own exams. And so, they're trying to wrestle with this notion of what a minimally competent person is in a profession, and how do we assure that when we're letting you in the door on the front end, giving you a license, that we know that you're safe. And therefore, each state may vary a little bit in these entry requirements. Talked a little bit about adopting administrative rules, but I think the interesting thing here is most rules outside the legislation itself are more malleable. They're more about how things get accomplished. And so boards have statutory authority to create different rules around the implementation of the law, or to clarify a law. And those things go through revisions. They go through public discourse. They're open to change and reviewed on a regular basis. And this is often a time where athletic trainers advocate for some change in how the board is doing something relative to a law. And adopting rules allows boards to be a little bit more flexible. And with regards to the scope of practice, a lot of rule enables states to be more flexible in how they see scope and what skills fall into scope. As long as it's not specifically dictated in the statute, they can kind of create some boundaries around scope of practice in rule. And those are more malleable. They're more flexible than when you put it in statute. The rules can be revised. The rules will get on a regular basis, get reviewed. And so the rule allows some flexibility to the boards, which is quite nice when you talk about, doing things like scope of practice and reviewing things like scope of practice. You want more of that authority in rule, because it allows boards to be more flexible over time as professions change. So last kind of drumbeat on this, right? The purpose of regulation is to protect the public. So just keep that crystal clear. Every decision they're trying to make, the reason that they came up with this law in the first place, is to protect the public. I have a link here at the bottom. This is the document that I wrote for the NATA that really talks about regulation. The rest of this presentation is going to kind of focus on the types of things that came and grew out of that document. But I wanted to make sure you guys had a true sense for the different types of regulation. And then within the context of licensure, some of the things that that licensure law empowers that board to do, and how that impacts how they see scope of practice and the types of things that they can do relative to regulating scope of practice. And sometimes they do a tremendous job of it, and other times they get carried away. This North Carolina dental board decision was really interesting, and it talked about how and it focused on how a particular dental board kind of imposed themselves on other licensed practices, so dental hygienists and the like. The licensure board only regulates those who are licensed underneath of it, and they can get carried away with trying to protect their turf, so to speak, or overreach in their regulation of beyond the people that they license. And so sometimes boards mean well, but sometimes they venture too far and they get into some real issues. And this one actually went all the way to the federal government, right? The Federal Trade Commission basically came back on the Carolina State Board of Dental Examiners and said, you guys have overreached here. So, the boards aren't the last say. They're not the only say. And boards can overreach at time and get carried away with how they try to regulate scope of practice within the context of their board. So let's talk about scope of practice. There's kind of two sides to this coin, and one of which I want to talk about, but I don't want to focus on. But scope of practice has been an issue in medicine for a long period of time. There are many scopes of practice. There are different states that have very differing licensing laws, and that's all a political process. That's what people don't understand. The act of legislation is inherently political, and so you have lots of differing factions, differing political action groups, different people in the state legislature that have different ideas on practice for a particular profession and boundaries around a particular profession. And what that ends up doing is it finds its way into how things are worded in law, and that results in lots of state-to-state variability and unnecessary limitations on practice that have nothing to do with education, nothing to do with minimal competence, and have everything to do with a political process. And a lot of times this is where from the outset a profession gets kind of boxed into a particular type of population, a very narrow scope, as it were, because of the different constituents within that state as this licensing law was being put together, having some say in what is in that law. And it's really the first place where you get this tension, this turf war, push-pull about particular types of skills and practices. And I find it disturbing in many cases that we look, in particular in today's day, that a skill is owned by a profession. Skills are skills. People can be educated to perform skills. No one profession owns a skill, but we tend to, when we write these pieces of legislation, have constituent groups of different professions who want to own a particular skill, and therefore they want it put in your law that you can't perform that particular skill. You'll see this reflected across the board in lots of different professions, and it causes this kind of interprofessional turf war and tension, which is a real challenge, because that kind of butts up against current medicine and medical practice. This challenge of trying to meet medical need for people, trying to manage chronic conditions, this notion of wellness and prevention, and let's work in medical teams to provide care, let's provide more open access to medical care, cheaper access to medical care, is kind of the direction that the government and medicine wants to focus, but it's in conflict with this notion of of exclusive practice and specialization and professional specialization. And so as we work our way through new models of delivering healthcare, we're going to have to think differently about how care is delivered and who's delivering it, right? So do we really want only one profession to be able to deliver care if some rural area in a particular state in the Midwest has none of those practitioners? Is there not another practitioner who might be able to step into that void and provide health care and deliver health care for people who need it, and do it safely, which is what the state licensure board should be looking at? And so I think we get some unnecessary turf war push-pull that goes on not only just in the legislative process and the creation of law, but even beyond that, once the law is written, and it really butts or flies in the face of what current medical practice is and kind of the desires that most are talking about relative to healthcare delivery in the United States. And so, but not only that, you're seeing education change. So as we start to see educations become more robust across professions, athletic training has changed drastically in the last 25, 30 years, in scope, in educational preparation, and the types of things that we're able to do. And other professions are doing the same thing. So as these scopes of practice expand and these practitioners become educated and safe in these different skills, it's going to necessitate a lot more overlap in scopes of practice across professions. And it's causing a lot more of these turf wars and arguments over who owns particular skills, or, that an athletic trainer can't do that. That's a physical therapy skill, or that's a chiropractic skill, or and you see these turf wars really becoming an issue. And this kind of what forced me into these discussions. We kept getting asked as a board questions about scope relative to other boards, and other boards asking questions about our scope, and are you practicing chiropractic medicine, or are you really practicing athletic training? And our athletic trainers trained to do this. And it's really where I kind of started. I started thinking about this from the kind of turf war side of the fence. And the more I thought about scope of practice and current healthcare environments, there's this massive overlap. And not only that, that overlap amongst professions is probably necessary for us to deliver, good, high quality, safe healthcare to the constituents of our states. And we probably ought not be wading into and thinking about exclusive skills, but rather whether people are trained and safe to provide these skills. And so I really spent a lot of time thinking about how do you peel this onion and get a real true sense for what a scope of practice looks like for athletic training. And so what I want to do is talk a little bit now about just that, the practice acts. What is this regulation? What is current practice? How does it fit with and provide boundaries around scope of practice for a particular profession? And I want to put it out there straight from the jump that I'm going to go over a bunch of practice acts. I could go through all 50 states and find differences. I'm going to give you some examples. I'm not casting judgment one direction or another on it. I'm using it as an example to show you how licensure laws and wording in laws helps define scope of practice. And I'm going to talk a little bit about my board experience and kind of what we think is best practice in discussing and trying to figure out what one scope of practice is. And it resulted, my thinking about this resulted in the last few years of my time on the board and in writing a document for the state, but also this document for the NATA that really talks about this growth in the profession, right? This athletic training educational explosion that's occurred has really resulted in this kind of, I think of it as kind of three circled approach to how you have to think about practice. One is what skills are being used and as athletic trainers fall into new roles, new practice settings, new ways of doing things, you're going to see that reflected in the role delineation study, right? So you see this change over 25 years and the types of roles and the types of practices that athletic trainers are being asked to do. So you see this expansion of scope reflected there. You also see that then driving what content's on the exam, what content's in the competencies, and education. So entry-level education has changed in its scope, and it's reflected the types of content changes that are necessary for people to be able to adequately perform these roles that they're being asked to do in the role delineation study. So you've got this kind of this interplay between education, the board of certification and its entry-level exam, its study of role delineation, and these all reflect to some degree these changes in scope of practice that are occurring, and sometimes the change in scope is driven by the education, sometimes the change of scope is driven by what people are doing on a daily basis and the role delineation study, and it drives changes in the educational process. So each player in this kind of helps really define what changes in scope of practice look like over time. And you've seen a lot of it in athletic training in the last 25 years. And so, in this NATA document, I talked a little bit about this notion of turf battles, and I don't want to spend any more time on that than just a brief kind of piece. What I really want to get into over the next few slides is litigation, questions of negligent practice, and when a board is asked, what's the scope of practice of your profession, or was this within this practitioner's scope of practice in a case? How can you think about that question in a meaningful way and come up with some reasonable answer or response? And so I'm going to spend the rest of this presentation kind of walking us through that process. So I'm going to try to stay away from this notion of turf battles, this notion that my practice includes this skill and therefore it's not yours. I don't think that's really a great way of thinking about scope of practice. In reality, I think we should reflect the reality that scopes of practices are going to overlap, and that as our professions evolve, there's going to be more and more and more overlap, and so we need to be way more complex about our thinking, and move beyond this notion of turf and practice being part of a particular discipline, and really into questions about, is this part of an athletic trainer's scope of practice? Was it within their training? Was that athletic trainer personally competent? Like, these are the kinds of questions that you're asking in cases of negligent practice or litigation or revocation of a license because of negligent practice, right? So it kind of flips from whether a profession owns a skill to more individual, and what was that individual in question scope of practice? What was their educational preparation, and is that educational preparation allowing that person to be safe? And because first and foremost, the board's looking at safety of the public. And so I really changed how I thought about the problem and really turned everything into focus on, okay, well then how do we determine if someone's safe? The central question the regulatory board should be asking, and athletic trainer professionals should be asking, is this person trained to provide and able to execute effectively in a safe and effective manner this skill? And if so, then it's probably within the context of their scope of practice. And so I said, okay, well then we need to set out a kind of a crystal clear way in which we can walk down that path and determine whether someone's scope of practice is adequate for them to perform a skill. And so I set out about trying to kind of flesh this out on paper. And in the end, I was always making sure as I wrote each piece, is this going to ensure that the public is safe? And in the context of this area that we're discussing in terms of scopes of practice, does it allow for safe practitioners? And so that I kept coming back to that question, this notion that we're ensuring the safety of the public that no one, practice is owned by a profession, but rather how do we determine whether this practitioner before us is educated to be safe on the practice of this skill. And so when we make decisions on scope of practice, we should be looking at 4 things as I worked my way through that. Is the task represented in entry-level education and practice? And then I broke out a whole series of sub-questions that kind of help you get at that answer. Has the practitioner had continuing education to adequately prepare them to perform the task? And this one's a much more gray area and very more difficult to flush out, but I think it's something that boards can do a good job of if they really kind of construct their thinking in meaningful ways. And so I came up with some questions to kind of help clarify that. Then C is really interesting. This is where you get into the statute and how that statute was written. Is the task specifically prohibited by that state's law? And one of the things that we're running into now, and we'll talk about some of these examples, is that certain states are precluding athletic trainers in their statute from doing things they have rightful education to do. Now that our educational process has evolved, people are being educated to do things, but the state law prohibits them from doing it. So it's quite interesting. And then last and probably the most important is, does it provide for the safety and welfare of the client? That's what state boards are really after and really trying to kind of nail down. So let's walk through these 4, and I'll give you some examples of different pieces of this or questions you might want to ask. So, is a task represented in entry-level education and practice? There's some different ways of thinking about this. Is it taught in accredited entry-level athletic training education programs? If so, then it's currently on the BOC exam as an entry-level skill. Probably it's entry-level. Now, there's some caveats there. If you were educated back in 1980, you didn't go through an accredited entry-level athletic training program. So we would have to look at what was your entry-level athletic training education at that time. Did this task fall under that? And if so, then it fell into your entry-level education, or or is it beyond what your entry-level education was, in which case we're going to have to go to the kind of the next step to figure out whether you were educated in that. And is the content clearly found in current and historic practice? Think about taping ankles, right? That's been part of athletic training practice across time. And so when we get questions about whether someone can perform that task, it's a pretty easy yes. It's been something that's kind of ubiquitous with the professional practice for a long period of time. And then you see the things that are entry-level competencies or found in the role delineation study. These are things that people are doing on a daily basis. It's clearly within the scope of practice of an athletic trainer, and those documents allow you a real clear picture of what entry-level looks like in athletic training right now. So, and so if it's found in the role delineation study, if it's part of the current competencies, and it's something that's on the exam, the board can feel, or you as a practitioner thinking about scope of practice can feel pretty rest assured that skill is entry level. So this just gives you some questions that kind of help you kind of more concretely look at whether the skill that you're questioning relative to scope of practice is represented in athletic training education practice. Where we get a much more gray area is this notion of continuing education. And this is where boards really wrestle with the individual case and the individual person. And I spent a lot of time thinking about some questions here that allow us to get some clarity around whether someone's advanced skill training allows them to practice that skill in a way that's safe. And so the first and foremost question, what training programs did you attend to learn a new skill or technique, and how many of them? How many hours have you spent on this? Was the time you spent adequate to acquire the skill? And that's not a real cut and dry answer. There are, in many cases, very little clarity on how long someone should have to practice a skill or get continuing education in a skill before they're really competent to practice that skill. And some skills are safer than others. I mean, just think about two of the current advanced skill training models going on right now, whether it's instrument assisted on one side of the coin and something as invasive as dry needling on the other, right? So you've got two advanced skills, but even within those, very different safety concerns. And so they probably ought to have different amounts of time spent and different content of depth in order to make sure that someone has acquired that skill. And so that becomes easier if the program has some standard or criteria established that you can say, oh, this person's got a certification, and that certification has some external agency who's accrediting them. Unfortunately, that's not the case with most of these programs. What you have is someone getting quote unquote certified by the person who's providing the education in the first place, and you have no minimum standard or criteria established for them to get that certification. It can be everything from attendance to next to nothing. So trying to determine what standards and criteria, if they are there, if it's established by an external group, you can feel a lot better about it. If not, then the boards have to kind of really flush through how competence is determined through this advanced skill program and how they can assure that that's there. I think physicians and medical practitioners who perform these tasks and our subject matter experts can give us some clarity on that. And that kind of dovetails in with 4 and 5. What are the measures of competence, and what are the validity of those measures, and did this person go through a program of study? Did they take exams? Did they show clinical competence with their skills? Did they have some way that they had ongoing monitoring? How many patients did they have to see before they could perform autonomous? I mean, there's all kinds of questions that dovetail in this. And so it really gets us to trying to provide some clarity. Things like 6, is there evidence within the profession related to particular procedures and skills involved in changes of scope? Does the profession really start to adopt a new skill and get really refined about how it's being delivered? Is it getting incorporated into entry-level education, or is it really an advanced skill? And if so, is there a way in which that advanced skill is uniformly thought about in a way that the board or the individual in front of you, you can determine whether they've met some standard in order to be safe to provide that. And so, and last but not least, is there evidence that that procedure or skill is beneficial to the client and not contraindicated? And if it is, then the person obviously doesn't even know enough about the skill to know when to do it or when not to do it. So making sure that they understand indications, contraindications, when it should be used, when it shouldn't be used, are things that you could even get into a discussion with that individual as they sit in front of you as a board, to kind of get some clarity on whether you think that person has had adequate education to perform the task. So these 8 questions were things that I thought enabled enough probing for us as a group to say, okay, as we look through all of these questions, are they allowing us some clarity on whether this person before us has had adequate training and this advanced skill, they've practiced it in a way that's safe for the public and that we feel comfortable that they're educated to perform it? So the third prong of determining this is pretty straightforward. Is the task specifically prohibited by state laws and rules? And each state is going to have a different licensing law, like we said, and they're going to be worded differently. But based on that, they're going to have some clear prohibitions in their laws. And I'm going to give you some examples of this. And so when I think about the kinds of restrictions, things like injectable drugs, performance of surgery, like these are things that you will see commented on in athletic training practice acts often. And they'll even get into lists of modalities and tools and things that really, the more things that they specify, the more restrictive the law becomes. And so questions to consider in this area is, what is this expanded scope clearly prohibited by a state practice act? Is this practice clearly prohibited by another profession? And I'm going to give you some examples of that. For instance, their surgery is something that's clearly prohibited, right? There's only certain professions who are able to perform surgery. And so, but these are in statute. These are things that the legislature voted on and put words to. And so we need to go back and look at what those look like. And where you're going to find those most often in these licensing law is in the definitions section. And I'm going to start here with Ohio and give you an example right out of our Practice Act. Athletic training is the practice of prevention, recognition, and assessment of athletic injuries. Right, so you've got a definition of what athletic training is, who it is that we can accept referrals from within the state. Right, so again, I can't accept a referral from, given our law, from a physician's assistant, for instance. They're not in that list. And so it's clearly drawing boxes around how you're going to practice your athletic training. And then you'll see things like I highlighted here, topical drugs. Athletic training includes the administration of topical drugs, right? And as we've changed, we've learned more about pharmacology. That is a restriction now, right? So there's only one type of drug that you can use if you're going to do injectable drugs or injections, or you're going to do an IV line or sutures, some of these newer advanced skills. You're not going to be able to do it with the use of injectable drugs, right? Only topical drugs. So just that one word, topical, makes a big difference in drawing a box around practice. And so these definitions become really interesting. So I went out and I just found some different states, and we're going to roll through some different examples. Here's Connecticut. Similar kinds of definitions. Athletic training means, right, they're defining what athletic training is, and you can see they get a little bit more intricate in that description. They have 1, 2, 3, look under 3, physical agents including but not limited to heat, cold, light, electrical. So they're getting very specific about the types of agents you can use in your practice, right? They're getting much more specific about things. And then you get to D, education and counseling to physically active individuals, coaches, medical personnel, right? This notion of physical active individuals is a really interesting one. And therefore, you know, many of these laws are trying to clear and kind of come back and clear up what that physically active individual or athletic injury or whatever the term is, that kind of really gets at patient population. I'm going to give you some examples of that. And then things like E, I think, provision of wellness care services for active individuals who are free of any underlying pathologies that are beyond the scope of practice for a person who's practicing athletic training. So they're trying to define what athletic training is in statute. And this really does then put boxes around the types of things you can do and what athletic training looks like in that state. These definitions get more and more complex. So within each of those, they talked about an athletic injury. Here's those two states and how they define it. And there's slight differences. And those differences are meaningful in practice. Athletic injury means an injury sustained by any individual that affects the individual's participation or performance in sports, games, recreation, exercise, or other activity that requires physical strength, agility, flexibility, speed, stamina, or range of motion. I mean, that's pretty broad. Any other activity that requires physical strength or agility or flexibility, that creates a pretty wide latitude in what an athletic injury is. In Connecticut, they define an athletic injury differently. Similarly, but differently. Injuries sustained as a result in participation in exercise, sport, a game, a recreational activity, or any activity that requires the level of strength, flexibility, and agility that's comparable to the level of strength, flexibility, agility required for exercise. So now they're saying not other activity that requires any amount of strength. It's got to be comparable to strength, flexibility that's required for sport participation or recreational participation. So again, a little bit different language that really changes how you can practice in the state. Those allow two differing populations, one a little bit more broad than the other, and you see them trying to clear up these pieces. We put physically active individual was in the original definition of athletic training. Now they come back in and they define what that is. A member of a professional, amateur, school, collegiate, or other sports organization, or a regular participant in activity, right? So these definitions become ways in which the statute regulates boundaries on scope of practice. And the way things are worded are really important. And you'll see these definitions becoming more and more and more, or more and less restrictive from one state to the next, and how each legislative process crafted that language really impacts the scope of that athletic trainer's practice in that state. Here's an example of one of those exemptions. Nothing in this law should be construed as authorizing an athletic trainer to provide surgery, osteopathic medicine, right? So now they're precluding you from doing particular types of other professions scopes. They're saying nothing in this law means that this person's going to be able to go do surgery, or is acting on as a surgeon, or a doctor of podiatry. Some additional examples. I went to some other states. So here's Colorado. This is their athletic definition. Athletic training includes, and I highlighted one piece, athletic training includes the services appropriate for prevention, recognition, assessment, management, treatment, rehabilitation, or reconditioning of injuries and illnesses sustained by an athlete who is engaged in sports, games, recreation, and exercise. Right? So they're saying, now you're saying it's restricted to an athlete. Right? So now you got to define what an athlete is, right? What does that mean? An athlete is a person in association with an educational institution, an organized community sports program, a professional, amateur, recreational organization or club sport, participates in games, sports, recreation, or exercise requiring physical strength, flexibility, range of motion. So much more here in this Colorado example, really driving their discussion much more honed in on athletic competition at all different levels, more so than the Ohio or even the Connecticut example, right? It's very much more specific to athletic training practice being restricted from a patient population standpoint to certain types of sporting programs and sporting organizations and the like. So it's interesting how these states, like I said, no one's better or worse. It's just an example of how these things change. Here's a Texas law, right? So again, similar kinds of things, practice of prevention, managing, treatment, right, of a licensed professional who's authorized to refer for healthcare services within the scopes of the person's license. Now, the interesting thing here, they go in and they talk about an athletic training injury, and it's very similar to Colorado, an organized sport or sport-related exercise or activity, including interscholastic, intercollegiate, intramural, semi-professional, and professional sport activities. So now even more specific to staying within the context of interscholastic, intercollegiate, intramural, semi-professional, very much sport-oriented versus the Ohio or Connecticut law, which gives you a little bit more flexibility in patient population, given the context of the wording saying, similar to, the strength, flexibility of blah, 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 right? So wording matters. And so when we look at the third prong of trying to determine scope, the way the law is written, the way these definition sections are written, really draws a box around patient population, what types of things you can and can't do, who you can and can't see, and a lot of the scope of practice comes out of that. So I encourage people when they talk about scope of practice to think about what way is that law written, what types of restrictions are there. Go look at the definitions, go look at what's written in statute, what's clearly prohibited and what's not, because every state is different, and the types of things that you might be able to do in Ohio may be different in Connecticut and different in Colorado and different in Texas. And so the fourth prong of that is, does this task provide for the safety and welfare? Like I said, ultimately, this is the primary obligation of the boards. We want to make sure that the task isn't putting the public in harm's way due to unprofessional or improper, incompetent training of the athletic trainer. And if they are safe, and people can have things in their scope of practice, they can use those skills for the benefits, and that doesn't necessarily mean that the outcome is always going to be good, but we can at least say that the skill that they were providing was within their scope. The outcome may not have had anything to do with them being incompetent or improperly trained. And so I hope this gives you some clarity on the types of regulation and what the purpose of regulation is, this duty for safety of the public, the current kind of issues around healthcare delivery, these expanding scopes of practice, how they start to overlap, and we start to get in these kind of turf war struggles that I think are fairly unproductive. But what I really hope you walk away with is this notion of kind of exploring those 4 types of questions. Is this part of entry-level practice? Has this person in front of me had continuing education that we find to be sufficient? Are they clearly staying within the boundaries of their practice act? And does this thing provide for the safety and welfare of the public? And if so, if you can answer all 4 of those questions affirmatively, then it's clearly within someone's scope of practice to provide that skill. And so the other thing I want you to take away from this, though, because of the way we frame this, there is no one scope of practice. Athletic training has no one scope of practice. Every practitioner, every individual has their own scope of practice based on their education, their continuing education, their growth as an athletic trainer. And so therefore, we can't just as simply say, well, yes or no. This is within a scope of practice. And even things that are entry level that new grads are walking out of their entry level programs with may be beyond the scope of someone's practice that was educated 20 years ago. If they haven't had Con Ed in those things, then it's not clearly in their scope of practice. And so we really need to look at the individual and what their scope of practice is. I hope this provided you with a new way of thinking about scope of practice. I hope it was helpful. I spent a lot of time thinking about this, and I really enjoy the concept of kind of fleshing through it and really trying to think more complexly about this notion of scope of practice and getting away from this notion that a profession owns a skill, and really looking at the individual and looking at how they were educated and what that means for the ability for us to expand scope of practice and provide better healthcare services to the people of our states. And I thank you very much.